Welcome to Watson & Associates LLC. We help domestic and foreign companies defend against Anti-Corruption and Foreign Corrupt Practices Act, FCPA, charges. We have offices in Washington, D.C. and in Colorado. We provide our clients and potential clients with information to help them start in the right direction. We encourage you to subscribe to the channel. More importantly, we highly suggest that you visit the description section in this video and download critical information that can prepare you for dealing with federal criminal cases. Now let's get to today's topic. Did you know that the largest fine ever paid under the Foreign Corrupt Practices Act was a staggering $2.9 billion? The magnitude of such penalties underlines the importance of businesses understanding and complying with this law. The implications of falling foul of the FCPA are far-reaching, potentially resulting in substantial sanctions and criminal exposure. It's clear that this is not a law to be taken lightly. So what is this law that can lead to such hefty penalties? Let's dive into it. The Foreign Corrupt Practices Act, or FCPA, is a U.S. law that prohibits bribing foreign officials to gain a business advantage. At its core, this law is designed to prevent the corruption of foreign officials through illicit payments or gifts. It's a heavy-hitting piece of legislation that's been on the books since 1977, and its implications are far-reaching, extending to conduct both inside and outside the United States. The FCPA's anti-bribery provisions are broad, applying to three categories of persons and entities. First, we have issuers and their officers, directors, employees, agents, and stockholders acting on behalf of an issuer. Second, we have domestic concerns and their officers, directors, employees, agents, and stockholders acting on behalf of a domestic concern. And third, we have certain persons and entities, other than issuers and domestic concerns, acting while in the territory of the United States. In essence, the FCPA prohibits the willful use of the mails or any means of interstate commerce corruptly, in furtherance of any offer, payment, promise to pay, or authorization of the payment of money or anything of value to any person. This is with the knowledge that all or a portion of such money or thing of value will be offered, given, or promised directly or indirectly to a foreign official to influence the foreign official in his or her official capacity, induce the foreign official to do or omit to do an act in violation of his or her lawful duty, or to secure any improper advantage in order to assist in obtaining or retaining business for or with or directing business to any person. But what if you find yourself in the crosshairs of the FCPA? Well, the law does provide two affirmative defenses. First, the payment was lawful under the written laws of the foreign country, known as the local law defense. And second, the money was spent as part of demonstrating a product or performing a contractual obligation, known as the reasonable and bona fide business expenditure defense. Remember, if you're the defendant, the burden of proof falls on you. This law is far-reaching, but let's look at a real-life example to see how it works in practice. In 2010, ABB Lut, a Swiss corporation, found itself in the crosshairs of the FCPA. The company, a leading supplier of power and automation technology, was charged with violating the FCPA's anti-bribery provisions. The charges stemmed from the actions of two of its subsidiaries, one based in the United States and the other in Mexico, that were alleged to have made corrupt payments to government officials in Mexico and Iraq. The U.S. subsidiary, ABB Inc., was accused of making payments to officials at a state-owned electricity board in Mexico to secure contracts. Meanwhile, the Mexican subsidiary, ABB Lutted Mexico, was implicated in a scheme in Iraq that involved kickbacks to officials under the United Nations Oil for Food program. The Department of Justice and the Securities and Exchange Commission led a thorough investigation into the allegations. The probe revealed a trail of illegal payments totaling millions of dollars, hidden through an intricate web of intermediaries and fraudulent contracts. As a result of the investigation, ABB Lutted and its two subsidiaries agreed to pay a combined fine of more than $58 million to resolve the charges. This fine was one of the largest ever imposed under the FCPA at that time. But the financial penalty was only part of the fallout. The company also had to invest heavily in revamping its compliance program and internal controls. A process that took several years and cost much more than the initial fine. ABB Limited's case is a stark reminder of the serious consequences of violating the FCPA. It shows that even international corporations with vast resources can find themselves facing substantial sanctions and criminal exposure if they fail to comply with this critical legislation. It also highlights the importance of having robust compliance procedures in place to prevent such violations from occurring. But the question remains, how can businesses protect themselves from falling foul of the FCPA? What steps can they take to ensure they do not find themselves in a similar situation to ABB Limited? The key to staying on the right side of the FCPA is proactive compliance and a strong legal defense. As you navigate the intricate maze of international business relations, it's essential to develop robust internal compliance procedures. This isn't just about ticking boxes, it's about creating a culture of integrity and transparency that permeates every facet of your operations. Now, should you find yourself in the crosshairs of an FCPA investigation, it's crucial to understand the affirmative defenses at your disposal. In the world of the FCPA, there are two main defenses: the local law defense and the reasonable and bona fide business expenditure defense. Under the local law defense, you could argue that the payment in question was lawful under the written laws of the foreign country. This defense, while potentially powerful, requires a deep understanding of the foreign jurisdiction's legal landscape, highlighting the importance of expert legal counsel. The second defense, the reasonable and bona fide business expenditure defense, allows for the argument that the money was spent as part of demonstrating a product or performing a contractual obligation. This defense requires meticulous record-keeping and a clear demonstration that the expenditure was legitimate and directly related to the conduct of business. But remember, these are affirmative defenses. The burden of proof lies with you, the defendant. This is why having a strong legal defense team is not just an option, but a necessity. Your legal defense team will guide you through the complexities of the FCPA, help you craft a compelling defense strategy, and advocate for your interests. They'll also help you respond to civil investigative demands, which are formal requests for information and evidence during an FCPA investigation. But the most effective defense is prevention. By investing in comprehensive compliance procedures and fostering a culture of integrity, you can significantly reduce your risk of falling foul of the FCPA. Remember, when it comes to the FCPA, an ounce of prevention is worth a pound of cure. The Foreign Corrupt Practices Act is a powerful tool in the fight against corruption. We've delved deep into the FCPA's provisions, understood its implications, and highlighted the importance of compliance through the ABB Limited case study. Remember, this act applies both within and outside the U.S. and covers a broad range of persons and entities. The key to avoiding trouble? Develop strong internal compliance procedures and always stay proactive. Staying informed and proactive is your best defense against FCPA charges. Ignorance is not bliss when it comes to the FCPA. Watson & Associates FCPA lawyers are available for immediate help. Please call us at 1-866-660-15518.